is the trafficking of human beings who are coerced into having their organs removed in return for money. Statistics indicate this is a lucrative industry with an annual revenue ranging between $850 million to $1.7 billion. Due to the significant revenue that can be created, well-known transplant tourism routes have been established in a number of countries, including India, Pakistan, Egypt, and Lebanon. So the minimum for an ethical transplantation process involves two forms of consent, or at least one of these forms of consent. Firstly, explicit consent systems. These are those that require explicit consent during a donor's lifetime or by family members after their death, or two, presumed consent systems, which are based on the presumption that the deceased donor consented to the removal of their organs. Accordingly, transplant tourism, which, as I say, perhaps is the least severe risk, undermines one of the key principles of ethical organ donation and transplantation, that is voluntary and informed consent. The World Health Organization is clear that in order for organ donation to be ethical, the donor must, quote, act willingly and free of any undue influence or coercion, close quote. Importantly, the World Health Organization does not consider a person to be willing if they are selling their organs for money or other benefits. The reason for this is clear. The average donor and recipient, the contrast between the two could not be more stark. A typical male donor is 29 years old, earning an income of US $480 per year, while the typical male recipient is 48 years old and earning around $53,000 per year. This disparity and the financial vulnerability of the donors that it exposes means that donations are very easily made under economic duress, where real consent is lacking. Consent of a kind given in these circumstances cannot be considered to be truly voluntary, as recognized by the World Health Organization. Circumstances matter, circumstances which lead to coercion and a lack of voluntariness in the consent or in the purported consent. This is at the heart of these unethical practices. And all the way then, let's turn to the sharper end of the scale, forced organ harvesting. This is the killing of a person so that their organs may be removed without their free, voluntary, and informed consent and transplanted into another person. Since the early 2000s, there have been concerns about such a system of forced organ harvesting in the People's Republic of China. At the beginning of the 2000s, the PRC leapt from a follower to a leader of transplantation technology. Despite there being no voluntary donation system, within 4 years, the country made impressive developments in the field of transplantation. Organ transplantation hospital numbers tripling, transplantation surgery expanding from solely kidney transplants to hearts, lungs, and livers. At the same time, transplant tourism and tourists were reported to have access to matched organs within a few weeks or months, while in other countries with well-established donation systems, it took years. The transplants were able to be planned in advance, with specific dates on organ availability provided to the recipient of the organ well ahead of time. This rapid expansion and the short waiting times in which people could access organs, of course, raised grave concerns on how organs were being obtained. This resulted in allegations of the existence of a state-sanctioned regime of forced organ harvesting of prisoners, including non-death row prisoners. In 2009, the PRC officially stated that 2/3 of all organs used in transplantations were removed from death row prisoners, asserting rather unconvincingly that prisoners had consented. However, research illustrated that organ sources had to include non-death row prisoners, including Falun Gong practitioners, as the execution of death penalty sentences declined since 2000, whilst the transplantation system continued to grow. Crucially, the timeframes also match up with the crackdown on the PRC's government on Falun Gong practitioners. For those who are not familiar with Falun Gong is a spiritual practice rooted in traditional Buddhist and Taoist teachings and is centered on three core principles of truthfulness, compassion, and forbearance, which guides practitioners in daily life. Prior to the large-scale campaigns commencing in 1999 aimed at eradicating the Falun Gong, including enforced disappearances, extrajudicial killings, and other grave human rights violations, the movement was popular in the PRC, including among state authorities. In 2010, the PRC announced that from 2015, the system of organ procurement from executed prisoners would end, and that they would begin to engage in efforts to establish a voluntary organ donation and allocation system in line with WHO ethical standards. However, research has shown that the number of organ transplant surgeries still substantially exceeds the number of registered organ donor numbers, and as made clear by the judgment of the China Tribunal, to which I will turn in a minute, there is no evidence that the significant infrastructure associated with China's transplantation industry has been dismantled, and absent a satisfactory explanation as to the source of readily available organs, logic and common sense dictates that forced organ harvesting continues to this day. Please refer to the advisory report for more discussion on these issues. Turning to slide 9, concerning these barbaric practices, the China Tribunal and its judgment are of critical importance. They constitute the first extensive and independent review and evaluation of a significant body of evidence from experts and facts-based witnesses on forced organ harvesting in the PRC. Led by Sir Geoffrey Nice, a well-known human rights and international criminal lawyer, but also with a panel of esteemed experts in the field of international criminal and human rights law, cardiothoracic surgery, business and international relations, the judgment was damning. It found beyond reasonable doubt that 1, Falun Gong practitioners were serving as the principal source of organs for forced harvesting in the PRC, and that the widespread or systematic attack of forced organ harvesting, together with other criminal acts, constituted crimes against humanity. These findings were subsequently corroborated by 8 UN special rapporteurs and 4 UN human rights experts in June 2021. They reported that they'd received credible evidence of ethnic minorities and other groups being forcibly subjected to blood tests and organ examinations within China, and that these were, quote, credible indicators of forced organ harvesting, close quote. There is more evidence. The Uyghur Tribunal, again led by Sir Geoffrey Nice, again found evidence of forcible harvest system within China, this time against Uyghur detainees. And so with this type of reporting, the risks are clear. And the risks are widespread and systematic. They inevitably concern, therefore, a wide range of medical professionals who work in the transplant industry, not just those at the most proximate position, the transplant surgeons, anesthesiologists, nurses, and so on, but also professionals who might be considered more ancillary, such as the suppliers of medical equipment, fluids, and drugs, clinical research institutes, those who engage in professional development programs, medical journals, academic exchanges, and so on and so forth. So these are the risks, and these are those who will encounter those risks. And those risks might be and should be considered to be legal risks. The legal risk of complicity, complicity is a broad term, but it encompasses a huge range of ways in which individuals and organizations can be legally responsible for contributing to human rights violations of this kind. In the advisory report, we focus on aiding and abetting because it's the most commonly known form of complicity. It's routinely used in international criminal law tribunals, and it's routinely used at the national level. It means the practical assistance, encouragement, or moral support, which has a substantial effect on the perpetration of a crime. It doesn't require that the person or organization intends the crime, more that the individual or the organization intends to contribute to the crime. There's a difference there, as you'll appreciate. This is discussed more in detail in the report. Aiding and abetting is, as I say, one of the modes of responsibility in which an individual or an organization can find themselves in a courtroom at the international level or at the domestic level. And if you're talking about the sharp end of the practices within the transplant industry, you're talking about crimes against humanity. And crimes against humanity fall to be prosecuted under universal jurisdiction principles, which means that anyone, or any state rather, should be prosecuting those crimes regardless of where they were committed. Indeed, if you look globally, there is a growing trend on a domestic level for these types of crimes to be prosecuted, and a growing trend on a domestic level for businesses to be prosecuted for their links to such crimes. In the last year alone, representatives of 2 French companies and 1 Swedish company, as well as a French company, have been charged by public prosecutors for complicity in international crimes. Charges were brought on the basis of the companies being indifferent to international crimes, despite them being aware of their tacit involvement. Again, I repeat, it's not about the company intending the crimes. It's about the company being aware of the risks and nonetheless going ahead and taking those risks, and in the end contributing to those crimes. Of course, in the end, what we're talking about is proximity to crimes, proximity to violations. And in practice, this of course means in terms of the transplant industry, and this is what we discuss at length in both the advisory report and the policy guidance, there is a sliding scale of risk and involvement. For those who are involved in, for example, publishing transplant research, the risk will probably be much lower. But for those who are, for example, supplying or distributing medical equipment essential for successful organ removal, for example, to a military hospital, which has been reported to forcibly remove organs, then the risk is clear and present and probably significant. And so, finally, how do we deal with those risks? How should the transplant industry protect against those risks? First of all, to ensure that they don't contribute to them, but also to ensure they don't suffer the reputational damage which inevitably arises if cases are highlighted or prosecuted against them. We deal with this at length in the advisory, but also particularly in the policy guidance. A number of steps are essential and mandatory according to international law, and can be summed up and found in the United Nations Guiding Principles on Business and Human Rights. They place a responsibility on states to protect rights, and they place a responsibility on businesses to respect human rights. And this is not simply a declaration, it's about initiating processes. And these processes are outlined in the UN Guiding Principles. At a minimum, medical institutions must 1, establish a human rights policy, 2, conduct ongoing human rights due diligence, and 3, disengage from relationships where the risk cannot be prevented mitigated, or remediated. Now, I won't go into huge detail on these points, but I'll just make a few points and then I'll turn over to the rest of the panel. A human rights policy is a public statement that has to be adopted by the executive level and senior management of an institution. It can't be palmed off to somebody in the HR department. It has to be adopted and embedded within the organization. It cannot be a paper tiger. It needs to be a live instrument which describes the commitment and ensures that the organization lives up to the commitment. Human rights due diligence. This is the core of the responsibility and the means by which an organization within the transplant industry can respect human rights and keep itself from contributing or causing or being linked to human rights violations. It involves identifying human rights risks. It involves then formulating responses to those human rights risks, tailor-made to the organization, tailor-made to the severity of the risk, and tailor-made to the activities of the organization. And it's not a one-off requirement. It's a requirement to identify and confront and to continue to evaluate the response and evaluate the effectiveness of the due diligence. And so finally, as I say, there has to be a line drawn. If those risks cannot, according to due diligence, be remediated, then the organization should be disengaging from those risks and should be disengaging from those relationships. This is not just a commitment that is required under UN guiding principles, but is also one which will keep the organization from encountering domestic problems of legal enforcement. Increasingly, countries such as Belgium, France, the UK, United States, Canada, Australia, and New Zealand have domestic laws which are hard law, civil responsibilities, criminal law responsibilities, which if an organization within the transplant industry falls foul of them, then they will find themselves in front of a courtroom being prosecuted or investigated according to those civil and criminal law demands. Please have a look at the legal advisory report, and we detail what those hard law requirements are. So let me finish here, and I can pick up on any issues during the Q&A. But a starting point is that those institutions within the transplant industry must take steps. The risks are clear. The risks need to be further explored, and the medical institutions and professionals within the transplant industry should be proactive in identifying the risks and dealing with them. Anything less is likely to leave the industry and the organization hugely exposed. Thank you, Lara.
Many thanks, Wayne, for that insightful overview of the legal advisory and policy guidance. And I think some really important points brought out there about the sliding scale of risk present in transplantation medicine, and the fact that it doesn't need to be your direct actions that create culpability, but practical assistance that understands the involvement, but nonetheless turns a blind eye. What I want to do in a minute is turn to the other panelists that we have here today and give them an opportunity to speak for a few minutes on their involvement in transplantation medicine and their interaction with these human rights risks. In that time, really good if the members of the audience could think about any questions that they have in relation to any of the comments made by our panelists, as well as any comments that were raised there by Wayne. So with that, Martin, I give you the floor.
Thank you very much, Laura. Well, my background is as a pediatric cardiothoracic surgeon, and I was involved in thoracic organ transplantation from 1988 onwards. And I think it's fair to state, first of all, that transplantation has always seemed, to me at least, to be one one of the highest points of human generosity, people consenting for their organs to be used to save the life of someone unknown to you or largely unknown to you or your family. And I was invited in 2016 to put my name forward to become a member of the China Tribunal, and was honored to be appointed. And the China Tribunal was a people's tribunal created to assess and pass judgment on evidence of forced organ harvesting in Chinese detention camps. Perhaps naively, prior to that, receiving and reviewing that evidence, and despite having spent half my working lifetime being actively engaged in transplantation, I was completely unaware that these activities were going on. We'll be able to discuss that later, perhaps. But when I read and heard the evidence, it was shocking to read it, and even more so to hear in person the oral evidence of brave victims of detention and torture. It was shocking to realize that physicians must have been complicit for these actions to have taken place. And it was in many ways more shocking also to hear of the involvement of a state in such activities in a programmed way against a population of people, and the way in which relevant and necessary clinical and activity data were either withheld as state secrets or obfuscated in such a way that their full meaning could not be determined. Incidentally, all the evidence that we heard and read is available to you on www.chinatribunal.com, and later evidence to the Uyghur Tribunal at uyghurtribunal.com. I think the links will appear in the chat. Now, good medical practice relies on the sharing of relevant information and on openness and transparency of both clinical results and research data. In most countries, there's an incredibly strong ethical framework which exists, and particularly so in transplantation, to govern our activity and to protect the patients. And also simply because there are huge data needs. You have to know an awful lot about the donor and an awful lot about the recipient to make sure that that match is as good as possible. And also to develop an audit trail so that when the organ is transplanted, you can look backwards and see where the organ came from in case any diseases develop. Those ethical frameworks are fundamental and they should be maintained. Now, communication between physicians, both within and between countries, is the norm in our business, and it has fostered research and led to rapid progress, and certainly my field and myself have benefited from both. But those relationships rely on trust, transparency, and truth. And sadly, the China Tribunal identified a state and within it individuals involved in practices which were patently unethical, crimes indeed against humanity. Now, many organizations in all of the countries which you represent have licensing authorities, academic institutions, hospitals, and individuals who, with good intention, strike up relationships with reciprocal structures and people in China, often making money from that. These links are actively encouraged by the CCP, Chinese Communist Party policy, via what they call the United Front Work Department. Such organizations, the Tribunal concluded, the China Tribunal concluded, must recognize to the extent that our judgment revealed that they were interacting or will be interacting with a criminal state. And it's against this background that I am really pleased that the GRC has defined this outstanding framework of a rule-based approach to the interactions which organizations, be they academic, medical, corporate, should undertake in order to do appropriate due diligence and manage their relationships with either the state or the organizations within it. I'll stop there, Laura, and hand back to you. Thank you.
Many thanks, Martin, for that insight and into the China Tribunal and your work in the industry. So, Julian, can I pass the floor to you?
You can. I've had some terrible anxieties getting onto this platform, so it is a delight to actually be connected with you. I'm here representing this evening the Human Rights, Medical Ethics and Human Rights Department of the British Medical Association. And I want to start off just making really a few basic comments that I don't think are controversial. And that is that, to start with, medicine is a morally inflected practice. The focus of medicine, the principal focus of medicine, is to bring benefits to human beings. For much of its history, medicine has not been, it's probably worth saying, particularly potent. Medicine has been said historically, it was what the doctor did largely was hold a patient's hands until sufficient time had passed to see if the patient would recover. But in the 19th century, post-Enlightenment, we saw a tremendous increase in the power, in the potency of medicine. It became effective. Knowledge of human functioning, knowledge of human ailments, knowledge of human pain systems and human responses became much, much, much more sophisticated. And obviously this led to a surge of hope that medicine would bring and continue to bring enormous human benefits. And then something happened in the 20th century. And this is where human rights and medicine came together. And what we saw in the 20th century was the moral inversion of the practice of medicine. We saw totalitarian states co-opt forcibly, in some circumstances, in other circumstances without coercion. We saw states co-opt medical practice for the destruction, either the direct and deliberate destruction or the indifferent destruction of human beings, of human bodies, leading to profound distress in the medical profession about the uses to which its extraordinary technologies, its extraordinary insights had been pushed. And that was the moment really at which we saw the development both of the human rights movement in medicine, or the human rights or the medical engagement with human rights, but also this increasing concern, this gathering concern about ensuring a protection of the proper moral purposes of medicine. And to précis brutally, right at the heart of that is the issue of informed consent, of a respect for the free and deliberative choices of patients. That's right at the core of the moral practice of medicine. And when we are looking at forced or coerced organ harvesting, it is clear that we are seeing a fundamental violation of the moral core of medicine, and that is set out in professional codes, global professional codes, the World Medical Association, declarations of Helsinki, declarations of Geneva. These are some of the kind of fundamental codes that govern the practice of medicine globally. And what we are seeing, what we have seen in China, the kinds of things that Martin and Wayne have been talking about, are a fundamental inversion, a perversion of core professional responsibilities in medicine. The British Medical Association has been pressing for years now to raise the profile of human rights issues in medicine. More recently, in relation to China, we have been pushing at the World Medical Association, raising our concerns on international fora. Fundamentally, and this is partly echoing what Martin has said, it is the fundamental obligation of all serious professional medical associations to engage with this issue, to call this issue out, and to take steps at the highest possible level to eradicate this grotesque and inhuman practice. So I'll leave it there.
Many thanks, Julian, for some really interesting insights there regarding the history of medicine, the ethical nature of the profession, the relevance of human rights, and the role of medical associations when it comes to enforcing those rights. And I think that that will be a point that we can return to in a minute. Next, I will hand the floor to Jörg, who can provide a bit more insight into the ethics of research and the interaction with journals. Jörg, the floor is yours.
Thank you very much. It's a pleasure to be here and also represent academic journals. Academic journals are, if you like, the stewards of the scientific literature, of the achievements as in science and medicine as they get documented. And that obviously is also a responsibility for academic journals. What is very important is that the body of the scientific literature on which scientific progress or medical process is based follows all ethics standards, is compliant with international laws, with international ethics. And on this topic, for example, there's standards on ethical organ transplants set out by the World Health Organization, by the World Medical Association, and also the Transplantation Society. So there are existing standards and ethics standards around organ transplants that have been documented, and in my view, the academic journals are the stewards of those and need to ensure that what they publish and what gets out into the community follows those guidelines. And journals have implemented, for example, checks around ethics approval in clinical trials and related topics for now decades. And it's also equally important that not just the rights of patients, but also in terms of organ transplants, the rights of those that are donating organs are considered and also are ensured. So how I came to this topic was in 2019, early 2019, Wendy Rogers and colleagues, they published a study based on also, I think, the work of the China Tribunal, where they analyzed the scientific literature for studies on organ transplants that took place in a period, in this case in China, up to 2016 or so, and identified studies of concern where potentially organs may have been used from prisoners, where consent or appropriate consent would not have been possible. So when I became aware of that as editor-in-chief of PLOS ONE, we looked into this. So for context, PLOS ONE is one of the largest journals in the world. At the time, it had published more than 200,000 studies in the space of 10 years. So it is a very large journal, and it has published across all the disciplines. And we looked into this and we identified about 21 studies of concern that were published around in the time frame in the country that probably needed to be assessed. So what we did is, the studies were already published, but what we did is we went back to the authors and asked them for documentation about ethics approval, as well, local one, as well as documentation about the donors. You know, what were the nature of the donors, where did these organs came from, and we heard nothing back, or very little, or argumentation back that everything followed local laws and regulations, which I don't know, may or may not have been the case. But there was no documentation forward, and given the concerns and the evidence that was presented at places like the China Tribunal, we decided to retract those studies. So there were 21 in total that were retracted in 2019, over the summer of 2019. So each case was looked at individually and assessed individually. And yeah, we retracted all of those. And those were also largely those that were identified in the study by Wendy Rogers. And yeah, and from my perspective, that is a necessary step for an academic journal to take. There's another journal, Transplantation, who also took immediate and very fast steps. But to my estimate, maybe only about 10% of the studies that were, or less than 10% that were identified by that independent study were actually retracted. Some have seen an expression of concern, which is basically an editor saying, well, there seem to be some concerns around that study, and the editor is concerned about this. But largely, we have seen not too much action on those. And my call for academic journals would be, that these concerns need to be taken seriously. That studies that violate international ethics standards, even if they may be in accordance with potentially local laws, need to be considered and assessed whether they should really be part of the scientific literature and the body of academic achievements on which we build our own progress. So that is a perspective where I'm coming from the academic journals, and I think academic journals have an important role. Journals are used for career progression. Publishing in a journal can be very prestigious. It's used for career progression, and journals need to make sure that ethics are maintained and that they are not supporting violations of international ethics standards. And that's just not, and this may not necessarily only be in the area of transplantation, as someone mentioned in the Q&As. There may be other subject areas where there may be similar concerns. I would agree with that. Thank you.
Many thanks, Jörg, for sharing those important views and making that call to action for medical journals and academic journals and editors to take more action. Especially interesting your views on seeing editors as stewards of ethics and your experience with journal articles that have come across these issues and been suspected not to be in compliance with ethical guidelines. Thank you very much for that. Finally, I will give you the floor, Cecile. So perhaps you can speak a bit more about your role in the work of the CMA. The floor is yours.
Thank you very much. And thank you for my co-panelists who have really set the stage well. And I won't repeat anything that you have said. I can tell you that I completely agree from the perspective of the Canadian Medical Association. I do want to preface my comments by saying that I happen to live 5 minutes from Parliament Hill in Ottawa, Canada, and I often see protesters who are in fact protesting on this issue. I personally and professionally did not appreciate the depth of this problem until I read the China Tribunal judgment, and I want to congratulate you for the impact that this has had. So I do have a few, really just a few slides, just because it's good to have visuals, and really I'm going to spend just a few minutes here to review what has been done in Canada and what the CMA has done. As you can see here from the Senate of Canada, an article titled "Canada Must Not Be Complicit in Predatory Trafficking Industry," written by Senator Atolahan, who actually has championed the legislation in Canada. So there is currently legislation being considered. There have been three iterations of the bill. And each time that the bill was introduced, it was by the same sponsor, by Senator Atolahan. It first began as Bill S-240. It was nearly passed in both the Senate and the House of Commons, but the Prime Minister at the time prorogued Parliament and the bill died in 2020. In the following parliamentary session, the bill was reintroduced in the Senate as Bill 204, and at the time, the senator said, for the third time now, I've introduced a bill to make it illegal for Canadians to purchase organs without informed consent. Bill S204, the new iteration, is an attempt to put an end to transplant tourism, the effects of which have largely escaped public notice. And she continues at the time, this is in the second iteration of the bill, she says, my bill does not prevent Canadians from traveling abroad to receive an organ transplant through legitimate and legal means. I can appreciate the hardship Canadians face spending months or even years on organ donation waiting lists. So she does acknowledge the breadth of the problem. The bill, the second iteration of the bill, passed in the Senate, but did not make it past the second reading in the House of Commons because an election was called in August 2021, and the bill died on the order paper. So following this, leading up to where we are today, following the election in Canada, which was last October 2021, the bill was reintroduced, this time as Bill S223, and it has passed in the Senate and is currently awaiting second reading in the House of Commons. As you can see, the bill is titled An Act to Amend the Criminal Code and the Immigration and Refugee Protection Act. So as the legal advisory says, to which Wayne spoke, the amendment to the criminal code seeks to introduce a new section, which would make it an offense for patients to travel for organs, that is for transplant tourism, and for physicians to obtain and transplant an organ removed without consent, and would cover any conduct in connection with the removal of an organ without consent. And I quote here verbatim from the legal advisory, this broad wording of the provision leaves scope for transplantation physicians, nurses, and associated medical staff who train or otherwise interact with overseas medical professionals suspected of forced organ removal to commit an offense where they know that the organ was removed without consent or are reckless to the risk that it may have been removed without consent. So in addition to this, the bill also strengthens the Immigration and Refugee Act by rendering a person inadmissible to Canada if they are found to have participated in activity related to organ trafficking. So now in its third iteration, in the second reading in the House of Commons, the CMA issued a statement to essentially express that the CMA is deeply disturbed by ongoing reports of organ trafficking targeting minority populations in China, refers to both the China Tribunal and the Uyghur Tribunal that has presented compelling evidence. And we felt that it was important to actually call it out and make it real by identifying the nature of the problem. The statement goes on to say that the CMA strongly commends these actions, and then goes on to say that the CMA strongly supports this bill and urges all members of Parliament to pass this important legislation before the end of the session. We have also, as part of our advocacy efforts, sent letters to all members of Parliament saying that the National Medical Association supports this bill and firmly believes that informed consent, to your point, Julian, is a fundamental requirement for organ or tissue donation, which must be obtained before organs are taken. And you would think that today we don't need to say this, but clearly we do. Informed consent, as Julian said, is a foundational pillar of modern medicine and medical decision making. So with that, we have had several opportunities for advocacy and have said that while the CMA supports current criminal code legislation that criminalizes the coercion of organ donation, we have advocated to say that that's not enough. And that we support the proposed amendments to the Criminal Code and to the Immigration and Refugee Protection Act. And I'm going to end here by pointing to two documents that essentially ground this advocacy work. I generally would have started with our policy, but I wanted to finish with it because to us, this is really the foundation in which we anchor this work. First is the CMA Policy on Organ and Tissue Donation and Transplantation. And as part of our revision of this policy, we consulted broadly And as part of this consultation, we have met with the coalition of organizations that you're familiar with, the Doctors Against Forced Organ Harvesting, Canadians in Support of Refugees in Dire Need, and the Human Rights Research and Education Center, and the International Coalition to End Transplant Abuse in China. They challenged the CMA to take on the issue of forced organ harvesting to their credit. And the initiative initially was quickly supported by over 500 Canadian physicians and by a few prominent individuals, including the former Minister of Justice in Canada, Irwin Cotler, whom you may know is an international rights lawyer. And as a result, this policy clearly states that the CMA discourages Canadians from participating in organ tourism as a recipient or donor. Physicians should not take part in transplantation procedures where it is reasonable to suspect that organs have been obtained without the donor's informed consent. And I know that this is a policy and many people question whether that's sufficient, but I can tell you that as the National Medical Association, many people will point to the CMA policy to anchor their activities and initiatives. And so it does have some gravitas, so to speak. And I'm going to end here by bringing it back to the Code of Ethics, the CMA Code of Ethics and Professionalism, which are essentially the profession's code of ethics in Canada, the medical profession in Canada's Code of Ethics. It articulates the ethical and professional commitments and responsibilities of the medical profession. It provides standards of ethical practice to guide physicians and the profession. And it's founded on and affirms the core values and commitments of the profession and outlines responsibilities related to contemporary medical practice. As part of the core values and commitments, I do want to point your attention to the Section B, fundamental commitments of the medical profession. The first one, commitment to the well-being of the patient, that physicians must first consider the well-being of the patient, always act to benefit the patient and promote the good of the patient. One would argue that would be sufficient in guiding physicians to never participate in what all of us consider to be morally abhorrent practices, profoundly rights-violating practices. But we felt that that was not enough, and consistent with the Code of Ethics from the European Council of Medical Orders, we added a responsibility to never participate in or condone the practice of torture or any form of cruel, inhumane, or degrading procedure. And I recognize that that does not specifically call out forced organ harvesting, but it does articulate the overarching obligation here, which again is part of the obligations of physicians in Canada. And that really is our foundation in which we anchor our work on human rights violations and broadly and specifically on forced organ harvesting. I'll stop here. Thank you. And I have to figure out how to stop sharing my screen, and I will. Thank you.
Thanks, Cecile, for sharing your views and outlining the legislative developments and challenges in Canada to address organ trafficking, transplant tourism, and forced organ harvesting, as well as the CMA's stance on these issues. Very grateful for your time. I think perhaps we'll use the last 25 minutes of this session just to answer some of those questions that are coming in from the different members of the audience. And one in particular, I want to start with. Someone asked, what are the next steps and what entity should be taking action to correct this grievous crime? China denies everything, and Lithuania is one of the few countries to take firm action. And I think that who is a really important question that I would like to ask our panelists to comment on. Perhaps talking about medical associations, transplant societies, governments, regulators, and who should play the key role in rallying a profession that, according to the comments of all the panelists, there is a low awareness of these issues. So, Julian, I see your hand is up. Perhaps you can start us off.
It seems to me beyond question that we need an independent review, that the only possibility, I think, of identifying precisely what is going on is for an organization like the United Nations to commission an entirely independent review of what is taking place, an investigation into what is taking place. And until such time as there is, as Martin has talked about, complete transparency about what is taking place throughout the organ transplantation system in China, these questions will endure. And it seems to me that we have got to look for a body of the stature and the global reach of the United Nations, but in my view, it would need to be independent of the World Health Organization, because both the UN directly and the WHO, as we know, are organizations that are vulnerable to political machination. So in my view, we must look towards, and certainly the BMA has called for such an independent review or investigation. I think we have to go there somehow.
Many thanks, Julian. I wonder, Martin, whether you want to add anything to that, particularly on the transparency point, which I know that you raised in your comments earlier.
Thank you. I think that the important thing in the context of transplantation, I'll limit it to that just for the moment, because there's some wider issues as well. The first is that for a successful and effective transplant program to exist, in other words, to know where a donor is and where a recipient is, a lot of information must have been collected and presumably stored. So any organization that wants to go in and look and see what is really happening is going to have to play with that paper trail all the way back to source. And I think everyone who's tried to get to grips with that paper trail in China has struggled enormously. And it's often held secretly. As a state secret, it's often distorted in some ways, and the publications that they have made about their data are fundamentally wrong. So I don't think it's going to be quite as easy for that group of people going in there to untangle all this unless they have access to all the data, which they can then cross-match with individual patient notes. Imagine that. With the added difficulties of doing it in different culture and different language. I think that's going to be a real challenge. The other point is that many of the investigations which have been carried out have already begun to identify key individuals, and I think I would have to hand back to the lawyers in the panel about whether individuals can be named maybe under Magnitsky regulations and dealt with. I certainly don't know enough about that, but I would like an independent inquiry to dig through this. I just think it's going to be really, really hard, A, to find a panel, and B, to get permissions, and then B, to be able to do the work, C, to do the work. A, B, and B is not so good. B and C to do the work. Maybe I'm just being a bit pessimistic about that, but somebody ought to be brought to book. But how you do it is more one for Wayne and you, Laura, I think, than for me.
Well, I will pass it to Wayne. Wayne, do you have any comments on that?
Well, I'm also, I think, skeptical of an international inquiry. I think with China's position on as a permanent member of the Security Council, with its long reach, on top of that, I think international inquiries take a very long time, and there's a certain cumbersome character to them, which in circumstances like this can neutralize their effectiveness. To my mind, and I see this in international criminal law, and human rights generally, when we're looking at the possibility of international action or more local action, then often more local action is more desirable and in the longer term more effective. And so taking this back to the advisory report and the policy guidance, I think national states have to start insisting upon this kind of due diligence. And I think that that type of due diligence involves demanding from, and it's not just China, but countries which have unethical transplantation systems, it would require those countries to answer serious questions and to be more transparent. And I think that's the key, is pressure to encourage transparency from users and beneficiaries and industry insiders. It's a slow but steady and incremental pressure, but I think one that will get there in the end. And that may sound a bit idealistic, or it may sound the opposite of idealistic, or too cynical and too slow and too ineffectual. But I see that as, in a sense, the way that human rights outcomes improve by local action, demanding change and demanding, for example, that simple things like the UN guiding principles, how often are they even mentioned within the transplant industry? I suspect rarely ever. So there's huge room for improvement, just to encourage and pressure industry insiders and organizations within the industry to apply the relevant law. And I think that would have significant would lead to significant improvement. I think there's more hope there, I think, than demanding outright that China cooperates with an international inquiry.
And Martin, I'll pass the floor to you in a second, but just to follow on from that, Wayne, we've had a question in whilst you were speaking. Do the panelists think that strategic litigation could form part of the armory of battling these human rights violations, for example, against pharmaceutical companies?
Well, I as a lawyer who works looking for opportunities to strategically litigate, I think that may well be one of the most effective ways to bring about change. If you look at enforcement in relation to businesses, or rather, if you look at the way that businesses routinely, and I don't just mean the transplant industry, I mean across the board, business routinely ignore their international obligations to respect human rights. And they'll continue to do so without enforcement. And I think we've seen a massive improvement, or a significant improvement in business adherence to human rights obligations since there's been a few high-profile cases against companies, and I mentioned some of them in my presentation. They haven't even led to necessarily to, or many of them, the recent ones over the last few years, haven't led to final disposition or final judgments or even adverse judgments, but every single one of them acts as a real incentive to businesses who then begin to get worried that they're going to be next with all the consequences that flow from that. So the simple answer is, I would say strategic litigation may well be the stick to beat some of the companies with, and to force change.
If I can just come in there briefly, Laura, I think I would agree with that as well. But what the GRC is doing with this document too is to put some obligation on all of us who come into contact with these organizations to have a high index of suspicion, which is quite an important thing. The comment also about who has influence over these organizations, certainly corporate ones, I don't think we should underestimate the change that's happened in the investment community through ESG type of investments, environment, sustainability and governance. there's been big changes in the way boards are held to account by outside investors. And I think groups like this could put a significant amount of pressure on those investors by exposing them to this information and forcing those boards to act according to your regulations. The members of the tribunal chose not to campaign because we felt the judgment should stand on its own. And I think that's quite important here, that others with your skills have to take this up and take this on, because it's not something that as individuals you can do.
Many thanks. We've had a question in regarding, Julian, your mention of the Geneva Declaration. The audience member asks, in relation to the WMA's resolution on academic boycotts and sanctions, forbidding sanctioning of individual doctors for their country's political or social policies, what does the panel feel about the ethics of this, particularly with transplantation medicine or birth prevention, as was detailed in the Uyghur Tribunal? This sort of activity requires systemic involvement of specialists in planning and implementation, in contravention of the Geneva's Declaration provision not to use my medical knowledge to violate human rights and civil liberties. I know that's a long one. Does anyone have any thoughts to start us off? Julian?
I mean, I would be opposed to, I think, the ordinary censure of doctors, individual doctors in the PRC. I think I'm not an expert by any means on the PRC, but those who I've spoken to suggest that there simply isn't the scope of liberties that we would ordinarily expect. So I would be reticent to move in that direction. But I think 20 years ago, I went to a meeting in Brussels about China, and we were invited before we went into this meeting to not foreground Chinese human rights abuses, but to be cooperative, to be collegiate, to engage constructively. And 20 years later, we're in a position where we have proof beyond reasonable doubt that the medical profession in China is engaged in genocidal activities. I think the collegiate approach has had its day, and it is time that we took strong action. But I would personally be wary about engaging with individual doctors. But I think the profession as a whole, the medical profession as a whole, has an obligation to engage with this issue in China. And I'm agnostic as to whether individual specialties is the way forward. I simply don't know enough about what's going on in China and the structures of medicine in China. But I think collegiality and engagement may have run its course.
Thank you. Yes, absolutely.
Thank you. I'll answer the question differently. I think that one could think of this as a question of the same considerations that are raised by dual loyalty. In this case, it's not necessarily a question of dual loyalty, but dual obligations. I think it's important to consider that physicians in China probably are themselves coerced into doing this. And so, how much can we actually achieve of what's happening in China is really in question. And that's the case for any human rights violations internationally. But I do think that there are things that we can do in our own countries and Western countries, and encouraging and perhaps even mandating for physicians to not be complicit, not participate, or even be complicit. And that I think can have some impact. But I really think that that's where we could affect the most change. And as the National Medical Association, I think that that's really what would be within our scope. Once you start not participating or being complicit in these activities, it can affect some change. Clearly, it's not going to stop the practice, but I think it could certainly reduce the scope of the practice, because right now we truly are complicit without knowing it. In addition to, we need to go farther than raising awareness. We need to start encouraging, like I said, perhaps even mandating. But I at least from the perspective of the National Medical Association here, that is what we can do. I'm not sure, how much change we could affect in China, given that, there's very little that can be done on so many issues in China, truly, if we're actually honest with each other. So anyway, just to say, to turn this around and look at what can we do that could be effective. And I think there are a number of very tangible things that can be done that could affect change. I'll stop here. Thank you.
Yeah, and may I just jump in? And that, in a sense, and I completely agree with Cecile. I think, I think that's what we're trying to say, in a sense, in the policy guidance, that the starting point is to look at what we can do in terms of our own engagement with dubious transplant industry, countries, practices, and so on. That's got to be the starting point. It seems to me sort of leaping over all the action we can take to clean up our own house, and immediately going to sanction individual doctors or individuals within the Chinese transplant industry. And I don't think anyone from this vantage point can look at those individuals and say they are autonomous, independent actors who choose willingly to engage in those activities. Some will and some may not. I mean, this is the reality of an authoritarian country. But what we can say for sure is that we have plenty of scope within the transplant industry to conduct due diligence and determine whether we continue, I say we, I'm not in the transplant industry, but the transplant industry engages with the research industry, research house, or surgeons or academic journals, and determine how to engage with them, and whether to continue engaging with them if they fear that there are human rights risks.
Absolutely, and I think that's a nice segue to you, Jörg, just to talk about your kind of call to action for the research publications. You talked about the fact that many of them didn't even retract articles, and what would be your recommendations for other research papers that perhaps didn't take as strong a stance as Plus One did at the time of the independent assessment of those articles?
Well, first of all, it's never too late. Journalists can still act, and they should act, in my view, given that the evidence is only increasing on these particular concerns, and should take a view as whether there's any documentation from authors that would support an ethical transplant, where there's mounting evidence that this was just fundamentally not the case. So journalists need to act on that. And the second thing, what we did, at least at Plus One, is on the back of that, we committed that if you publish a study on transplantation, you need to put into the study as well, as part of the methods, if you like, or your description of what you do, where do the organs come from? Are they, are ethical standards followed? What are the considerations from the donors and so on? So that needs to be in the study. And then also the editors, the manuscript editors that handle these submissions, they also had the liberty to ask for actual documentation, and that's for any country where they had any concern. It's not just to identify particular countries or so, but just generally speaking, there needs to be a stronger vetting, if you like, of the international ethics standards, and that's journals still need to do and can implement now for anything that's submitted, so that it doesn't even get published if there are concerns. So that would be the second step. So first of all, looking back at the literature and retract, which basically retracting means you declare that as a journal you cannot stand behind the study anymore. And the second thing is to do the appropriate vetting on any new submissions that come in to ensure that that these international ethics standards and human rights are followed.
Thank you. And may I ask the other panelists, to wrap up with, from their perspective, what would be their call to action for those stakeholders that they interact with, including transplant associated entities and societies and professionals. Martin, perhaps we can start with you. And who should lead this call? Thank you.
Well, I'll start with the first part of the question. I think that all the organizations who are managing medics, if you like, so that's the professional bodies, in the case of the UK, the Royal Colleges, the CMA itself, grant-giving bodies and licensing authorities each have a major responsibility. And individual hospitals, if they're setting up relationships with other hospitals, have to do it as well. So one of the good bits about the work that you've done is to provide that framework. So I'm very much in favor of that. The second thing is, I mentioned the high index of suspicion. China still has hundreds of thousands of people in camps. These people are at risk of medical experimentation at the very best, and other harms at worst, perhaps. So it would be crazy of us to go forward into the next decade without a much higher index of suspicion than we've had in the last decade. And finally, to push the point about transparency, I think I have a little bit of optimism, which I'd like to throw in, which is what the NIH have done in the United States, which is to state in terms that every body who gets money from them to do research has to publish or store, make accessible every single piece of data associated with the experiment, positive or negative. That is the best thing to happen to science for a very, very long time. And I would hope that everybody around the world will do the same thing, and the countries which don't will find themselves excluded from publication simply because they're not doing that. I think that will make a big difference. On a personal level, worry who you're talking to.
Cecile, if I ask you for your concluding remarks and a call to action.
As I said, and I think as we're all saying, this is so morally abhorrent, and we know enough about this now. There is compelling evidence that there is a systematic industry on forced organ harvesting. And as Wayne said, there's no reason to wait for a smoking gun. In many ways, there is already a smoking gun. And we need to act both by raising awareness and actually taking steps that we know will affect change, even if it doesn't completely stop the practice, if we want to be honest with each other. But we can certainly curtail it in a very significant way. And I congratulate all of you for your leadership in working on this and bringing this to everyone's attention. Particularly want to congratulate the BMA's leadership on this issue. It really has been exemplary. Thank you.
And Julian.
Gosh, thank you, Cecile. I noticed also my colleague, Dr. John Chisholm, is in the audience, and he's the former chair of the BMA's Medical Ethics Committee and currently deputy chair of the Medical Ethics Committee, and he has been an extraordinary driving force in this. And his actions, particularly his actions in bringing these issues to the World Medical Association, have been extraordinarily effective. And I'd like to commend him on that. I agree with everything that Wayne has been saying about the possibilities of actions related to compliance throughout, if you like, the industry of transplantation. But from my perspective, with my BMA hat on, this is a matter for global medical professional leadership also. The profession has to call this out. Somebody said in one of the chat bars that China is sensitive to global public opinion, and I think that is true. And I think it behooves the medical, it's a fundamental moral obligation of the global medical profession to continue to call this out, because it is such an obscene inversion of fundamental moral obligations in medicine. China is enormously powerful. These industries are global. There are going to be all kinds of opportunities to influence, but the profession also has to take a leading role in calling this out. We have to find a way to ensure that medical professionals do not engage in these kinds of activities.
Thank you. And lastly, I'll hand to you, Wayne, for closing remarks.
I'm not sure I could better what's been said, but we do know enough. Transparency is key. Calling it out is key. Due diligence, as we discuss in the policy guidance, is key. So read and adopt our proposals. And I am confident that if enough organizations, if enough of the industry adopted that kind of due diligence, improvements will follow. Bad actors in any industry react when their bottom line is threatened by customers, by beneficiaries, by those who engage. And so it's in the hands of those who regulate and work within the industry to force change. And it starts with their own due diligence.
Well, many thanks to all the panelists for their insights today. It's clear that there is a legal and moral responsibility to conduct due diligence, to identify and assess those human rights risks, and that those responsibilities fall on the medical community. I want to thank all the attendees as well today for their great questions, and urge anyone with follow-up questions to get in touch with Global Rights Compliance. We are a friendly bunch, and we're always happy to answer your questions. Equally, I would like to thank all of our panelists again, Wayne Jordash, Professor Martin Elliott, Dr. Julian Schieder, Dr. Cecile Bensimon, and Dr. Jörg Keber for making the time to take part in today's launch event. And with that, I close the session. Thank you all.
Thank you.